Hello, friend. Today we're going to talk about Section 37, Children Act 1989. Section 37, subsection 1 states that in any family proceedings in which a question arises with respect to the welfare of any child, where it appears to the court that it may be appropriate for a care or supervision order to be made with respect to the child, the court may direct the local authority to undertake an investigation of the child's circumstances. From my experience, this sort of orders are made in private law proceedings. It's not that it cannot be made in any other proceedings, but most of the Section 37 orders are made in private law proceedings involving usually child arrangement order applications. Once the court is considering the issue of whether or not to make a Section 37 order, the court will usually be faced with considering the allegation of the likelihood of a child suffering or a child who has suffered significant harm, and whether that child requires the intervention of a local authority. Once the court considers that it is necessary to make a Section 37 order, the court will make inquiries regarding the child's circumstances. And where it is absolutely necessary for the child to be safeguarded, the court may make an interim care order or an interim supervision order in respect of the child for the duration of the Section 37 investigation, even before the local authority reports back to the court about whether it is necessary to apply for a care or supervision order. When the court makes direction dealing with Section 37, there is usually a time period when the local authority must respond and provide the result of its investigation. It is expected for the local authority to carry out an investigation and determine whether it is necessary to A. apply for a care or supervision order in respect of the child, B. provide services or assistance for the child or the family, C. take any other action with respect to the child, and D. determine whether or not the child can be assisted without the need of an order. Usually the outcome of the local authority's investigation is expected around about 8 weeks after the court directions are made. And it will usually be prepared in the form of a statement. If the statement provided to the court lends support to the making of the application, the local authority can launch an application for an interim care order using the statement prepared in response to the Section 37 inquiries as evidence in support of its application for a care order or a supervision order. The report will now be considered at a hearing subsequently, when the court will decide what order to make or whether not to make any order. or whether to not make any order. I hasten to add that it is not unusual for a Section 37 direction to be renewed in the following circumstances. 1. Where a Section 37 report has been provided to the court as part of the investigation, but more time is needed to carry out further investigation before deciding what step to take, the court can then give another period of 8 weeks or whatever period of time is required to enable additional investigation to be carried out, and then the court will then consider the matter. Even when that happens and the court reads Section 37 report and finds that there are gaps in the assessment, the court can then request for a further investigation to cover the gaps. At all times, the paramount consideration of the court is to secure the welfare and the safety of the child. We shall now consider a couple of cases where the court made a Section 37 direction. In the case of A and B, open brackets, contact, close brackets, number 4, reported in 2015, EWHC, from page 2839, FAM. And in this particular case, among other things considered by the court, the court made a direction under Section 37, which then prompted an application for a public law order by the local authority. In another case, the case of H, open brackets, children, close brackets, reported in 2015, EWCA CIV, from page 115. Also, in this case, the court made a direction relating to Section 37 Children Act 1989, and I will read the relevant portion. The paragraph 17 of the judgment, it states that there was, however, a significant change in the character of the proceedings on 13 December as the case moved for the first time into the public law arena, which presupposes that it was previously in private law arena. The court made an interim supervision order and ordered the local authority prepare a report under Section 37 Children Act 1989. In another case, the case of E, open brackets, a child, close brackets, Rev 1, reported in 2018, EWCA CIV from page 550. In this case also, the court made direction relating to Section 37. And I will read the portion of the judgment where it states in paragraph 96 that during the course of Section 8 proceedings, it may become apparent to the court that additional factors are in play which are of more concern than the inevitable distress to a child upon family breakdown or in a medical treatment case to the understandable chasm which had opened up between clinicians and parent, unable to agree a way forward. The Children Act 1989 provides for just such an eventuality through Section 37, Children Act 1989, which states 37.1, where in any family proceedings in which a question arises with respect to the welfare of a child, it appears to the court that it may be appropriate for a care or supervision order to be made with reference to him. The court may direct the appropriate authority to undertake an investigation of the child's circumstances. We shall also look at one more case dealing with Section 37. In the case of S, open brackets, children, close brackets, reported in 2016, EWCA CIV from page 83, the court considered the issue of Section 37. And in this particular case, I'll read the relevant section. So the judge, when she became involved in the proceedings, Judge Moore was concerned that a care or supervision order may be necessary in respect of K, as well as in relation to the appellant's child. On 16 May 2014, she therefore directed the local authority to undertake a Section 37 Children Act investigation of K's circumstances. She appointed a guardian for K and provided for her also to have the benefit of representation by a solicitor, but K was not joined as a party to the proceedings. The role of K's guardian and solicitor was in part related to the Section 37 direction and in part to the question of K giving evidence about the sexual abuse allegation. In respect of the latter issue, the remit, as defined in the 16 May 2014 order, was to ascertain information about K, including about her maturity and her vulnerabilities, and as to what her wishes and feelings were about giving evidence. So we see in this particular case that the Section 37 report was to investigate the child's welfare. And I think I will not look at another case. Thank you very much for listening to this video. Thank you. Bye.